Welcome to Case by Case. This is a podcast brought to you by Luke Sadkovich and Callum Chain. How are you, Callum?
I'm very good. How are you doing, Luke?
I'm good. I'm actually really looking forward to this one. I know I say that every time, but this one is pertinent for a few different reasons, some of which are kind of in the realm of politics and Donald Trump and, I don't know, other sorts of things affecting juries and what they can do.
Well, it's a slightly political case. We've got ourselves a political hot potato, but I think we can handle it with our normal sensitivity.
Oh, of course. And when I say Donald Trump, it doesn't actually involve a case involving Donald Trump. It is a case all about jury equity. So not something we come across every day, I dare say.
I saw this in the press and I thought this is an interesting case, this is an interesting principle of law, a foundational principle of criminal law. But for people who are interested in law generally, then it touches on some very interesting issues about what you can and can't do and what juries can and can't do. And I thought it would be an interesting one to talk to you about.
And is it a principle, or is it a power, or is it a right? You know, all these kind of distinctions without a difference, as they call it.
What we're talking about is the fact that if a jury decides something on their conscience and ignores the law before them, then there's not really any recourse against the jury members for doing so. It's odd that it's allowed, but it in some ways would be more odd if it wasn't allowed.
It's a tension that the law tolerates, which I love. I love that phrase. Anyway, before we talk more about it, let me just get the citation out of the way. This is a High Court decision from England. Her Majesty's Solicitor General as the claimant, seeking leave to bring contempt proceedings, I should be more precise, against Trudy Ann Warner. Neutral citation number is 2024 EWHC 918 KB for King's Bench. This was delivered pretty recently on the 22nd of April 2024 and heard only a few days before that on the 18th of April. Some well-known cases arguing this. Quite a fascinating one. And the facts of the case go to, it is, I suppose, political in a way. It goes to the defendant who was standing outside the court with placard, I suppose you could say, which has ultimately been described as a human billboard here, which had some handwritten words on that placard that said, "Jurors, you have an absolute right to acquit a defendant according to your conscience. Jurors, you have an absolute right to acquit a defendant according to your conscience." The claimant, Solicitor General, brought contempt proceedings against the defendant, saying that this was interfering with the administration of justice, deliberately targeting jurors, and basically going too far and trying to get the jurors to acquit climate change activists when the law before them would lead them down a different way. So that's the kind of platform for this discussion, this placard, and what the defendant did and whether that was interference with the administration of justice.
A lot of the time we deal with cases where you have two corporations that are having a dispute, and it's often a contractual dispute, and there can be significant amounts at stake. There can be significant repercussions in commercial cases. Of course there can. But this is something of a slightly different tenor because it's effectively someone, this Miss Trudy Ann Warner, facing this claim against her for contempt. It's a very serious kind of individual potential exposure, being a potential sanction against her. And what she's done is she's stood outside the court, as you say, holding up a handwritten note saying, "Jurors, you have an absolute right to acquit a defendant according to your conscience." What was quite interesting here is they went through in detail at the CCTV to see what exactly she was doing. And they talk in the judgment a little bit about how she thought that was every, firstly, she didn't know who the jurors were. It was before jury selection had actually happened in this case, the first day of the trial. And there was one point where she thought that everyone had come in, and then she saw some more people, so she hurried back and held her sign up as quickly as she could. There was nothing on the facts where she was in any way intimidating to people or in any way aggressive, or it seemed as though she had no conversation with anybody. She was kind of just silently holding up this banner, which simply said, "You have an absolute right to acquit a defendant according to your conscience." There was a part of me reading through this and looking at the looking at the description of the CCTV that was slightly baffled that the Solicitor General brought this action at all. I felt that most keenly, and the judge, I think, was having a bit of fun with this almost. He mentions, he talks in detail about this principle of jury equity and its place in our legal system. And as you say, Luke, it's got this. It's an interesting concept that as a juror or as a jury, you can find someone not guilty despite the evidence before you suggesting that they are guilty, and there's no power to compel you to find somebody guilty. What jumped out to me that I thought was quite funny is that actually in the court, she was stood outside with a plaque saying you can find someone not guilty on your conscience. Inside the criminal court is a plaque, and the plaque reads, "Near this site, William Penn and William Mead were tried in 1670 for preaching to an unlawful assembly in Gracechurch Street. This tablet commemorates the courage and endurance of the jury, Thomas Fear, Edward Bushell, and 10 others who refused to give a verdict against them, although locked up without food for 2 nights, and were fined for their final verdict of not guilty. The case of these jurymen was reviewed on a writ of habeas corpus, and the Chief Justice Vaughan delivered the opinion of the court, which established the right of juries to give their verdict according to their convictions." This made me laugh a little bit because I shouldn't laugh. It's obviously someone's gone through a real ordeal having this hanging over their head for however long the legal system has taken to get to this point where it's been thrown out. But you've got a woman stood outside who is kind of, in slightly more modern language, said exactly what a plaque inside the building reads. And she's now having to defend her position in the courts.
Well, there's kind of 2 parts to this decision, aren't there? There's the jury equity discussion, and then there's whether there was actually contempt in this instance. And we'll talk about that in a moment. But quite clearly, the judge wasn't impressed with the application that had been brought, and that this didn't get close really to the level required for contempt. But we'll come on to that in a moment. But as you bring up there, this plaque, and it's fascinating, isn't it? Because when you think about the whole system of a jury, what it represents, it is a group of lay people, not lawyers, they're not judges, who are selected from the population at random. So they should be a representative group or representative sample of just everyday people, I suppose you could put it like that, who make a decision on whether there's guilt or no guilt. And there's all sorts of legal standards and directions that get given to the jury. And the court's very clear in this to say the legal directions are a fundamental part of how the jury system works. And indeed, the court will only give the jury the legal directions on the law and how to go about it and set the framework for then the jury to come to its decision. And importantly, the court does not set out this, I think it's probably best described as a power or principle, this principle of jury equity, that a jury can decide not guilty on the basis of its conscience and not necessarily following the legal principle. But that's not read to the jury. That is not something that's actually presented to them. So I find it a kind of fascinating concept where there's a clear tension there that has existed for years and years and years, that the juries have this ability to rule on their conscience. It's not really advertised to them. Most of them probably don't know. At the same time, if they make a decision based on their conscience, notwithstanding the legal principles that were put before them, there's not much you can do about it. That is the ability of a jury, and it's always been the ability of a jury, and it's a principle that has remained undisturbed and been looked at in the highest levels of the jurisdiction in England in recent times, and it's not been touched. Now, if Parliament wanted to change that, they wanted to make it binding that juries have to follow the legal direction given to them, and they can't use conscience to come to their ultimate decision, then Parliament could do that. They've had the opportunity to do that. It's been put to them. It's been an issue that's raised, and they haven't gone down that route. So it remains. It's a principle that's in place, and it's not just in England. This is also in the United States and other jurisdictions like New Zealand and Canada.
There are 2 points I'd add to that. One is I think that jury members take an oath, or they give an oath, that they will make a finding kind of in accordance with the law. Don't know the exact terms of the oath, but I think that they would be going, if they were to go purely on conscience and against what they knew the legal position to be, then they would be in breach of that oath. But there's no repercussion for breaching that oath, is the way I think it works. So you've got this weird situation where it's not kind of advertised, as you say, to the jury that they have this entitlement or absence of repercussion if they do this thing, but it is in a sense because it's celebrated as a part of our constitutional landscape. And as the judge was keen to mention, this is set out on a plaque in the criminal court. It is fundamental to having a jury. It has to be a fundamental principle of there being a jury. Is that really for criminal, there is that human element of criminal conviction that you have to be found guilty by this jury of your peers. If the jury is forbidden from not towing the line of the legal direction they're given, then there is very quickly less sense in the jury existing at all.
Exactly. But also fear of repercussion. And that's what the plaque goes to, is that who then sits behind the juror as judge and jury of the juror, whether they followed legal principle or not. There's areas of grey in this, and it's a very difficult situation. You either move away from a jury entirely and go towards judicial, qualified, experienced fact finder, or you kind of you have this built in. And as I say, it's not just in England; it's in the United States as well. And this has, it crossed my mind. I hadn't read this case yet, and I just read this today. Over the last week or so, there has been global news around the Stormy Daniels case involving Donald Trump and the allegations of covering up a payment to Stormy Daniels through Trump's lawyer at the time, Cohen, and whether that was done so as to hide, quote unquote, allegedly all of that, but hide from the electorate that this payment had been made, and whether this payment had been done in a way that suppressed it from formal records so that the electorate didn't find out before the last election between Donald Trump and Biden. And so what has been playing out over the last week, 2 weeks, has been jury selection. There is a jury in place now and they're into the trial, but it was a complicated process because this is a case happening in New York. Donald Trump has moved out of New York. He's now in Florida. And this case is being tried in New York. And so the court had the unenviable task of trying to find a jury that could be neutral in coming to a view on whether Donald Trump is guilty or not guilty of the alleged crime. It struck me through that process it's a really complicated, theoretical issue to get your head around, Callum, where, people are being selected at random. They will have views on Donald Trump or not because he was the president of the country, right? Unless you've been hiding under a rock.
Who doesn't have a view on Donald Trump one way or the other?
If you don't have a view on Donald Trump and you are going through a jury selection process to find a jury of people who don't have an opinion on Donald Trump or, some view on him, you've got to ask yourself, who are those people? And is that really a representative selection of the electorate,
Yeah. It's true.
You know what I mean?
That's true. When it's an interesting question. When you have someone so polarizing, then a representative sample is going to show the polarized ends of the spectrum, which is exactly what you can't have in a jury.
Yeah, exactly. But then you have a jury of apolitical people who sit in the middle, which in itself is not representative of. Anyway, I think it's fascinating. But coming back to this point, in the US, in the US and Doherty decision in the United States Court of Appeals in the DC Circuit, which is mentioned in this English decision in paragraph 19, Judge Lenthenhall describes how in the United States the existence of an unreviewable and unreversible power in the jury to acquit in disregard of the instructions on the law given by the trial judge has for many years coexisted with legal practice and precedent, upholding instructions to the jury that they are required to follow the instructions of the court on all matters of law. The judge notes that this is an accurate description of the position in our jurisdiction, as in England as well. So it's this unreviewable and unreversible power to acquit in disregard of the instructions, coexisting, this tension with the jury being required to follow the instructions of the court on all matters of law. Yeah, you think about that jury there that's sitting there listening to the Stormy Daniels case, if I can call it that. What ultimately sways them one way or the other is not reviewable and it's unreversible.
And I can see why in certain situations that some people might say that's a beautiful freedom, and other times they might say that's an immense frustration. But it's just part and parcel of a legal system that has this element of a jury, a kind of, if you like, consent-based system in a way, where you have to have these members of the community who you answer to if you've committed a criminal act, who have to sit and find out, have to sit and determine whether or not they're going to find you guilty. And in some ways, it's actually amazing how rarely this comes up. That was one of the things that kind of struck me, is that this is a very, for give you an example, it didn't come up in the case that Miss Trudy Ann Warner was supposed to be influencing. Did not go the way that she would have wanted it to be influenced. The protesters were found guilty, I believe. It seems to come up almost vanishingly rarely that you have a jury who go against the legal direction in a significant way, so that it causes some kind of issue or will get some press. It almost surprised me how rarely it comes up, given that it's given that there is this ability.
Well, how many people stop and read the plaque, Callum? How many people actually know about this?
Yeah.
They swear an oath that they're going to follow what the court says on legal principle. Do they really know that they can decide on conscience? It's a fascinating concept, actually.
It is. It's a great concept. I mean, I don't think we don't want to make this into a long episode, and I suspect that a lot of our listeners won't be hugely interested in the nuts and bolts of the way this specific decision went. But it's worth saying that the case brought for contempt was fairly panned by the judge, who looked at the actual conduct in a lot of detail and effectively said, you're not doing anything that comes close to any of the precedent that would suggest that you're, trying to actually influence a jury. You're not chasing someone. You're not kind of running them down. You're not being aggressive. You're not saying anything directly about this case. There's no kind of collusion to come to a different decision than the one that the parties were supposed to. It was literally just a lady stood with a placard that stated a principle of law, which is kind of constitutionally recognized by the English courts. My reading of this is that the judge took a pretty dim view of the Solicitor General for trying to bring this case.
I wonder why the Solicitor General brought it. I can only think that that there was some wider point they were trying to make here. But as you say, the court was not really impressed at all. I think it was described as fanciful. The court said it was fanciful to suggest that Miss Warner's behaviour falls into this category of contempt. The category is limited to threatening, intimidatory, abusive conduct or other forms of harassment, whether physical or verbal. Rejects the skeleton arguments that Miss Warner confronted jurors and that she followed 2 suspected juries to intercept them. They just mischaracterized the evidence. That's pretty strong from a court. To say that a skeleton argument mischaracterizes the evidence, not for pleasant reading. And I just wonder whether part of this was the Solicitor General being concerned about a precedent of criminal cases are coming before the court, that there are going to be people jumping out the front with placards saying, remember your conscience vote. There's something to that. This I think ultimately will dissuade people. If anything, has had the opposite effect, perhaps. You'll have everyone. You have 100 people standing out there in a group just as human billboards with, your power, and they won't write. They'll be clear not to write right, WR and then RI. They'll say it's a power. So that's been clarified here, I think, or even just a principle. They made that argument as well, that the placard said that it was a right when it wasn't a right. That was given short shrift. The placard didn't even say to the jurors what they should do, that they should exercise their right. They just were saying there is this right. And really it was accurate information, albeit you could say it's a power, not a right. But it's like information in the public domain, and the court was effectively saying, so what? It's essentially what the plaque inside the court says.
I don't know what the bigger picture was for this to be brought, but if the intention was to generate a little bit of legal press around jury equity and to make more people aware of it, then mission succeeded. I suspect that was not the aim. It's always fun talking these cases through, and I like it when we go a little bit off beat. And I saw this one come up, and I thought this would be an interesting one to get your view on. The kind of legal romantic in me loves this concept of jury equity and the idea that we have this system where any criminal conviction is, you have the structure of the court and all the processes of the court, but ultimately what it comes down to is a group of people within your community who have to make a decision on whether or not you've broken the laws by which that community has, the people of that community have agreed to follow. I think that's a very nice principle to have. And, it's good that it's not something that comes up every day. You wouldn't want this to be something that you see every week. But it's a nice little reminder that it exists. And the judgment is a nice kind of history of how long it's existed for. I enjoyed reading through it.
Well, I think it echoes all those Hollywood movies on courtroom dramas that, hinge on some extraneous, ethical, emotional heart tug on the jury that finds not guilty or guilty depending on the situation, when the evidence and the legal direction and everything else is another. But actually, there's something to that, There's something to that. What can the court do when a jury decides one way on conscience? Not all that much. It was fun. That was a good one, Callum. I enjoyed that. I hope you all listening in have got something out of this case, even if it was a bit of a laugh. And as to what happens in New York, have to wait and see. That's for another time.
Coming to a case by case for you, no doubt.
Coming to you soon. All right, take care, everyone. See you. See you, Callum.